to the cloud. There we go. All right, so we're recording now. And you guys can see my screen, my PowerPoint. It says Amazon Seller's Guide to Arbitration.
Yes. Yeah.
Perfect. All right, cool.
Are you recording this to share the recorder, the recording after?
Yeah, so the recording will be shared.
All right.
And we may post it on other platforms.
Cool, thank you.
No. All right, well, let's get started. So again, want to talk about arbitration with Amazon and what you guys need to know. And then we'll have questions at the end. Agenda, so we'll cover the Amazon BSA, the Business Solutions Agreement, and then we'll talk about what is arbitration, the pros and cons, advantages, disadvantages of arbitration, and specifically going up against Amazon, and then the process and fees for arbitration, and then we'll do Q&A at the end. So inside Amazon's BSA, which is Amazon's Business Solutions Agreement, which every Amazon third-party seller signs, whether they realize it or not, there's a section in there, I believe it's section 18, where that outlines and really details the arbitration process and how all of us are, all Amazon sellers, have to go through mandatory arbitration with the AAA, and the AAA is the American Arbitration Association. So this is pretty much word for word what the section 18 says. I just broke it down to make it a little bit easier to digest. So it says any dispute has to go through arbitration, and it's binding arbitration. The only exceptions where you could get out of arbitration and can actually take Amazon to court would be if you want to take Amazon to small claims, you can do that. However, most jurisdictions have such a low limit for damages. For example, here in LA, I think it's $5,000 per corporation. So if you've got 50,000 or 100 or $1 million in damages, small claims really isn't gonna do it for you. The other two exceptions address, or at least one of them addresses IP issues. So if you find that Amazon is somehow infringing or misusing your IP, you could take them to court for that. And the other exception would be Amazon can bring a lawsuit against you if you're selling counterfeit goods. So those are the three exceptions. Okay. One important thing, and this is what really gives Amazon a lot of power, is any arbitration case has to be on an individual basis and can't be in a group setting or in a class setting. What does that mean? You can't, if, for example, 5 of our clients have the same issue, we can't combine all 5 of their cases and represent all 5 of them in one proceeding, one arbitration proceeding against Amazon. They want each of these done in an individual basis. So no class setting. With respect to the fees, Amazon sort of discusses how they may reimburse you for some of the AAA arbitration fees. So if you have a claim against Amazon and you take it to arbitration and it's $10,000 or less, Amazon will reimburse you the arbitration fees. And it's not attorney fees, but just the fees related to the admin fees with respect to arbitration. The next thing is if there's expedited procedure. So this is a procedure with the AAA where they'll try to get through stuff a lot faster. So on average, it'll take about a year or so. This, they try to do it a lot faster. And so the only way you could join that expedited procedure with the AAA against Amazon is if your claim is only for monetary damages and it's $50,000 or less. And in a situation like that, they'll try to get you in front of an arbitrator within 90 days. So have a hearing within 90 days after an arbitrator is appointed. So what is arbitration? Everyone knows what a lawsuit is, what litigation is. Arbitration is another method of resolving disputes. So here it would be resolving any of your disputes you have against Amazon. In arbitration, there is no judge or jury, there's just an arbitrator. And usually arbitrators are either retired judges or like an attorney who does this on the side. Arbitration is less formal than an actual litigation, meaning it's more flexible with the schedule, with their rules and procedures, and usually less expensive than a full-blown lawsuit. One thing that they do state on Amazon's agreement is that the award has to be done on an individual basis, which we also mentioned, but they also specify that any award that a judge can award, an arbitrator can also do, which is true. Couple of distinctions between arbitration. So arbitration can be voluntary or it could be mandatory. Voluntary means if me and, let's say, company B have an agreement together and says, you know what, instead of a lawsuit, what we may want to do is first see if we could resolve our disputes via voluntary arbitration. That's where each party can choose whether to participate in arbitration or whether not to. With Amazon's agreement, it's forced arbitration, so meaning it's mandatory. You have no other option besides those exceptions that I mentioned earlier, but you have to go to arbitration. It's not voluntary. And there's binding and non-binding. Binding means that the arbitrator's decision is final and you can't dispute it and take it to court later on and say, I don't agree with the arbitrator's decision. Compared to non-binding, where it's sort of optional. You could go through the arbitration procedure, but if you don't like the final outcome or the arbitrator's decision, then you could say, you know what, I don't know if I like it, I want to take this to court. Again, Amazon's BSA, Amazon's agreement says that this is binding. One exception to the binding rule would be, even though Amazon's BSA states that it's binding, there's certain limitations or certain exceptions, very narrow, but where you could say, you know what, I don't agree with this final determination by the arbitrator and we're going to take it to court. But usually it involves something like if you believe that Amazon has done something illegal, such as bribing the arbitrator. In cases like that, you can. But again, 99.9% of the time, you're not going to be able to take it to court after it's been concluded, and the arbitrator's decision will be binding. The pros and cons of arbitration. So arbitration tends to be less hostile, meaning the parties usually in one respect or another are more cooperative and they're working together. And it's usually cheaper than litigation, it's faster than litigation, and it's private and confidential. So we've got several clients that we've taken to arbitration, and a lot of our other clients will ask, what was the outcome or what happened? And it's all private and confidential. Even the client themselves, they can't talk about it unless it's with their other attorneys or CPA or accountant or for tax purposes. So that's a double-edged sword, and we talk about that too when we get to the disadvantages. But for better or worse, it's private and confidential. Another advantage is they have a flexible schedule where if you're in a court setting, the judge will have pretty strict deadlines of when you need to do such and such. Here with arbitration, it's a lot more flexible, and if you need to extend any sort of deadline, they're usually pretty forgiving and will allow it. Another advantage is with the arbitration, you have simplified rules of evidence and procedure. It's not like in a court setting where you have to do everything by the book, right? Such as if you're in federal court, you don't have to do everything according to the federal rules of evidence. Here, you could be a lot more flexible, and the arbitrators are a lot more flexible too and a lot more accommodating. Another advantage is limited discovery. So discovery is where each side has questions or documents that they request from the other side, and the other side will go ahead and prepare them and provide it to the other side. That's discovery. Here, it's limited discovery, and it really depends on the arbitrator. We've had situations where an arbitrator just says, you know what, let's limit it to 30 or so questions from each side and 30 document requests. We've also had an arbitrator recently who was very, very strict and said, you know what, we're in arbitration because we want to save money, and that's the intention of arbitration. So we're not going to have any written discovery. If you have documents that you want to request from the other side, do it now, and I'll make sure the other side provides it. Okay, so it could really range, but generally it's a lot less discovery work compared to a lawsuit. And again, discovery is where things can get very expensive. And that's a big part of arbitration and even lawsuits. So those are the advantages. And then as far as the disadvantages of arbitration, arbitrator's decision is usually final. Again, we mentioned that earlier. So for better or worse, it's going to be final. You can't really appeal it. Uneven playing field. What does this mean? So because all of these arbitration proceedings are confidential, they're private, we as attorneys representing Amazon sellers, we can't see what arguments or what sort of procedure was done with previous cases. Where with a lawsuit, we could go back and look at common law, right? We could look at other cases that had similar issues and what arguments made and what judges maybe favored one argument over the other argument. We as individual attorneys, we don't have access to that. We only have access to the pool of arbitration proceedings that we worked on, right? Where Amazon gets to see all of it because they have one law firm based out of Seattle, Washington, that represents Amazon in almost all of their proceedings. So they have a larger pool, and I guess a complete understanding of which arbitrators to select and what arguments to make, and as far as when to settle and when not to settle. So that's why we wrote down as a disadvantage, uneven playing field. Next thing is questionable arbitrator pool. So part of the process of arbitration is the AAA will provide both parties, us and Amazon's attorneys, a list of 10 arbitrators, and then we get to rank them each side. So our attorneys or our law firm, I should say, and Amazon's attorneys will rank them with respect to, I want this arbitrator ranked first because I would want them, this is second, this is third, or this is 10th, or I don't even want any of these selected or even considered. So again, this goes back to Amazon's attorneys having a complete picture of which arbitrator is maybe more favorable or favors Amazon and Amazon's business or even their arguments compared to individual attorneys such as us or the other attorneys in the Amazon space, where we have a limited amount of information with respect to these arbitrators. And again, the last disadvantage I see is a lack of transparency. This goes back to what we just mentioned with Amazon having a complete idea of the picture of what arguments to make and which arbitrators may favor them. With respect to the roadmap or process, again, on average, you're looking at about a year. And again, most of it will depend on discovery, which we'll get into. But it all starts with filing and initiation of the arbitration proceeding. So the BSA requires that before you can file a claim or a demand for arbitration with the AAA, that you need to send them a letter, their registered agent a letter stating what your claims are and that you want to start arbitration. Once you've done that, you could go ahead and submit your demand for arbitration to the AAA and a copy of the BSA and then the filing fees. Once you do that, arbitration starts. Next step in arbitration is, well, once you file your complaint and all that, Amazon will respond and usually they'll deny everything, all the claims that you're making, and then also list their defenses. So that's sort of the filing and initiation process. The next step is arbitration selection. So again, they provide about a list of 10 people, 10 arbitrators, and each side gets to vet them. So they look at their CV, their resume, and make sure that there is no conflict of interest. And then you'll go ahead and rank them. So Amazon doesn't see how we ranked our arbitrators, and then we don't see how they rank theirs. We submit both of our lists over to the AAA. The AAA will take a look at it and choose one of them. Keep in mind, these arbitrators each have different backgrounds, different skills, different experience, and also different rates of pay. We've seen arbitrators that charge $250 an hour all the way up to $750 an hour. And we've also seen arbitrators that may charge for traveling and some that don't. We've seen arbitrators that say, you know what, I'm going to charge when we get to the hearing, I'm gonna charge for the entire day. I don't care if the hearing is only gonna last 2 hours, I'm gonna charge for the entire day. And the fee for the arbitrator, whatever their hourly rate is, that's split between Amazon and our client. Next thing is preliminary hearing. So this is the first time that both sides attorneys meet with the arbitrator, and there we're laying out what discovery is going to look like as far as what the limitations of discovery is, what the deadlines are, and we really set out the schedule. And this is the first time that all three parties meet. And if there's going to be any sort of settlement offer from Amazon, usually it happens at this stage, at the preliminary hearing. Okay. And once that's done, we'll start with discovery. Again, discovery is where each side requests documents and information from the other side. This stage can get very expensive because depending on the discovery that's going to be done, and usually each side will have issues about the questions or documents that the other side is requesting. So you'll have a lot of motions that are filed from each side and challenges as far as like, I don't think you need to see that document because of this and this reason, or I don't think you can have that witness because of this and that reason. So that's discovery, pretty lengthy and can get very expensive. So if there's ever an opportunity, a reasonable opportunity to settle, it would be before discovery. Sometimes you could even settle after the first set of discovery is exchanged, and each side gets to see how strong or weak the other party's position is. That's another opportunity where we've seen that a settlement can occur. So once that's done, we'll go ahead and prepare the briefs and everything, our arguments, and then get ready for the evidentiary hearing. Evidentiary hearings can be as short as 2 hours to 4 hours to a few days. But during the preliminary hearing, you'll also discuss how many hours or how many days you want to reserve for the evidentiary hearing, depending on how complex your case is or how many witnesses each side has will determine the length of the evidentiary hearing. Once the evidentiary hearing is done, then the arbitrator may have post-hearing submissions that they want you to provide to them. Okay, so those are additional documents that they may want to see or additional information that they want to gather from each side or maybe from one side. But once, again, that's not always, but sometimes, once that's done, arbitrator will go ahead and close it, and then within 30 days, they'll go ahead and issue a decision or an award. If the client, if the Amazon seller wins, then they'll go ahead and demand that Amazon pays them whatever fees or awards that they're owed. Okay, but that's the entire process. And then here, down here, we wrote down expected costs. So there's 3 different costs in arbitration. There's AAA admin fees, which we'll go over in just a minute. There's attorney fees. There's also arbitrator fees. So there's 3 categories of fees that you'll be responsible for. The AAA admin fees, they're usually set, and we'll go over it. But the attorney fees and arbitrator fees, those are going to be a lot more fluid. On average, for the entire case, I would say you're looking at spending $80,000 to $100,000 with all 3 fees combined. Again, that's average. Some may cost less, some may cost more. So this is a list of the American Arbitration admin fee schedule, and there's 2 sets of fees or fee schedules. One is a standard fee schedule, and then this is flexible fee schedule. So standard fee schedule, it breaks down the fees into 2 payments, and the flexible, it's 3 fees. So you'll pay in 3 stages. Okay. So all of it is determined on the amount of your claim. If your claim is less than $75,000, then you'll pay initial filing fee of $925 when you file the demand, and the final fee of $800. All right. And then if it's, let's say, $500,000 to $1 million, then you'd be paying under the standard fee schedule $5,500 to start, and then the final fee would be $6,825. Now, if you do the same case, the 500 claims $500,000 to $1 million, then you're looking at paying $2,750 to start, the proceed fee of $4,725, and the final fee of $6,825. So this will end up totaling to be more, but the understanding is that you'd be paying it in smaller chunks. And then if the fee is undetermined, then you would just be paying for this range. So 7,700, 84.75, or these three fees under the flexible fee schedule. And if it's non-monetary claims, meaning you just want them, for example, you're just going after them because you want them to reinstate your ASIN or your account, then you would fall under non-monetary, assuming that there's no monetary claims. Then you would pay 3,500 to start and the 2,750, or those amounts under the flexible fee schedule. In general, when clients come to us, if they have damages that are less than 150, I would say even 200, 250, we don't think arbitration is a good option. Generally, like looking back, the cases that we've taken to arbitration, they've had $1 million or more in damages. And I think that's when clients feel the most comfortable and we feel the most comfortable, because there's enough to justify the attorney fees, arbitrator fees, and the AAA admin fees, because those can definitely add up. But that's usually the cases that we've taken to arbitration. It's been over $1 million in damages. For the clients that have less damages, what we can discuss next time is synthetic arbitration, which is going to be a lot cheaper and a lot faster than going through the AAA arbitration procedure. But any questions or any comments?
No, I was muted, but no questions.
All right.
Pretty much, it's very expensive. Well, for instance, yeah, it's really, if it's for a known the last option there with any claim, there is really a hard decision. I have this friend. He has an account on Amazon, and his account was blocked because they found another registration. It's a company account. Mm-hmm. And they blocked his account because supposedly they had another account under the same company's name 5 years ago. Mm-hmm. And he keeps asking for them to cancel the other account, which he didn't know. He didn't even know he had. His wife did with the company's name. Now he's divorced and everything, and they can never solve that. They simply it's not that there is no money there. It was a new account starting to sell, but he's losing the account because of that. And all the answers that he gets on the cases are those templates.
Yeah. So that's a perfect example of what I was talking about, and I'll get to it in just a second. But I do want to address what you said as far as it being expensive. I don't want you guys to look at it just being expensive. It's a value proposition, right? Meaning, what is the cost? What is the benefit? That's really what you have to do. So for our clients, and I do agree with you that it's, arbitration should be used as a last resort. But for example, our clients that we took to arbitration, again, over $1 million in damages, the last two that I can remember, and we've got one in the pipeline now, the last two that we worked on, one had $1 million and the other one has 2.8, and we're still in arbitration with Amazon, right? And for those, as a last resort, they don't mind spending 100,000 or 120,000, right? Because the benefit is there. But now if you've got someone that has 25,000 damages, it doesn't make sense for you to pay $1 to get 10 cents back. So that's that. With respect to your other question, something like that, it sounds like it's a related account. I don't think arbitration is the route to go. I think maybe having a law firm like ours work on the plan of action or appeals. And if that's already been done and we feel like, you know what, that's been done well enough, then I would say synthetic arbitration. Let's go to their outside legal counsel and try to work it out. But that would be the approach that we would take. And just let you know, we're still recording. So if you want me to stop recording, because it seems like there's no other questions around arbitration, and if you have any particular questions about that, we could address it offline.
No, I'm not. I'm okay.
Cool. Yeah. All right, I'll go ahead and stop this recording.